Good. All right, we're good to go. Firstly, I've got to apologise if I'm in a bit of a mood this morning. I'm a die-hard Bulldog supporter, and I had to sit through what I've described as PTSD, re-traumatisation last night. Seeing the doggies lead and then seeing Melbourne run over the Dogs again. So I apologise if I'm not in the best mood this morning. But apart from that, today is really about looking at asset protection, protecting your wealth, and also your investment in your kids, because they are, at the end of the day, one of the most important things that parents invest in, and obviously making sure that that investment is secure. So as far as that goes, here at Aiken Partners, we've got a multidisciplinary practice where we've got a number of different areas where we work in, from family law, wills and estates, commercial litigation, insolvency, property, and commercial law as well. So we offer a diverse practice areas where we can assist you and your families in multiple areas. Today we'll be having Phoebe Smillie from our family law team speaking about protecting your investment in your children and what happens with respect to a family law split up with your kids, and what happens to any money loaned, gifted or advanced. Jack Conway from our Wills and Estates department will be talking about protecting your assets through estate planning and the different mechanisms that you can use to protect your wealth. And then Alex Nicol will be finishing off speaking about insolvency and family assets, essentially what happens when it all goes wrong. So without further ado, I'll throw it over to Phoebe to get us started talking about family law and protecting your investment in your kids.
Morning everyone, thanks for making it in so early today. First of all, I'll be talking to you today about how to protect any money that you happen to have given to your children and how we can protect that in a family law context. So over the last few years, we have seen our clients become members of one of Australia's 9 biggest banks. And that's not the Commonwealth Bank, it's not Westpac, it's not even ANZ, but it's in fact the bank of mum and dad. The Australian Financial Review published an article last year stating that parents are now lending, giving and underwriting record amounts for deposits to help their adult children buy their first homes. And in fact, parental contributions are averaging more than $90,000, an increase of nearly 20% in the last 12 months, with 60% of first home buyers now receiving financial assistance from their parents. The rise in popularity of this the bank of mum and dad is a result of a number of factors, and some of those are including wealth accumulated by parents, a rise in property prices across Australia, and the desire of parents to assist their children in buying their first homes. With the demand of the bank of mum and dad has also come the demand of parents wanting to safeguard and protect any monies provided to their children in the event of a relationship breakdown. This is a real concern for parents that in the event their child separates from their partner in 5, 10 or 15 years' time, a significant portion of their parents' money may be lost to the child's spouse. When looking at money provided from the bank of mum and dad in a family law context, it is important to determine whether that money was advanced by way of a loan or by way of a gift. So what's the difference between a loan and a gift in the family law context? In family law proceedings, a gift of funds means the parents have no expectation that that money will be repaid to them. The parents therefore waive their right to seek repayment or an interest in property which may be obtained with their money that was provided. For the recipient of the gift, in the event of a separation, the gift will normally be assessed as a direct financial contribution by the party who financially contributed to the asset pool. This may affect the division of assets between the parties in favour of the party who actually receives the gift. For example, if the husband's parents gave him money as a gift to contribute to the purchase of a property, the funds will usually be attributed as a contribution made by the husband. The husband may well then be entitled to a greater adjustment in his favour due to this extra contribution. But in any event, the funds will be included in the asset pool available for division, and the husband's former spouse may be entitled to part of these funds. In the event of a long relationship, the husband's contribution will have eroded and the court will likely find the contributions were equal and the spouse may have a greater entitlement to those gifts. On the other hand, if a payment from a parent to a child is treated as a loan, the child and their spouse will be expected to make repayments pursuant to the agreement that was reached with their parents. This will result in an overall reduction of the net assets available for division between the separating parents. So how does the court determine whether it is a gift or whether it is a loan? While this might seem like a relatively simple question, it can unfortunately be far from it. In some cases, it becomes quite complex determining whether the money was in fact a gift or a loan, especially if there is a lack of evidence documenting any intention between the parents and the child. Disputes often arise in family law because there was an informal or a verbal agreement between one of the parties and their parents in relation to the advance of money. In many circumstances, families do not formalise or document the loan, as there is an understanding or an expectation that the money will be repaid, and it is not anticipated that a relationship will break down. In other cases, the loan is documented, but the circumstances of the parties may change, and the loan is not repaid and therefore enforced. So in determining if funds are advanced by a parent to a child, the court will consider all the evidence to determine whether it was the intention of the parties that the sum be paid by the parent to the child on the condition that it should be repaid. And the types of factors that the court will consider are things like whether there was an existence of a written agreement, the terms of repayment, whether any loan repayments were in fact made by the parties, evidence of any discussions held between the parties as to the existence of the terms of the loan, whether there was a real expectation of repayment, and whether any representations were made to outside agencies such as banks or Centrelink. If the court is satisfied that the loan is repayable, the court may order the parties to repay the loan from the matrimonial assets. The court is less likely to consider a loan if it is vague, uncertain, or unlikely to be repaid. Where the court is not satisfied that the loan is repayable, then it is likely to determine the advance of money as a gift and treat it as a contribution made on behalf of the party whose parents paid the gift. So what can we do as family lawyers to protect any money given by way of a gift or by way of a loan to your children? In family law, our answer is always a binding financial agreement. And this is the best way that we can protect assets when entering or during a relationship. A binding financial agreement is colloquially known as a prenup. And it's an agreement which formalizes how a couple's assets, liabilities, and super will be divided in the event of a marriage breakdown or relationship breakdown. They're a cost-effective way to protect your assets that you've given to your children, your family's assets, which you have all worked hard to earn and to accumulate over the years. A VFA is an effective tool for a number of reasons, but for the purposes of today's seminar, they are great for quarantining and protecting assets which were required either before the commencement of a relationship or during the course of a relationship. They're a way to protect any gifts which have been provided by parents to their children. VFAs are not a one-size-fits-all approach. They can be tailored to specifically address whether or not a party has received a gift from a parent and how that gift will be treated in the event of a relationship breakdown. So I guess the lessons to be learned from this in the family law context is firstly that parents should always obtain their own independent legal advice before advancing funds to their children. Any loans from parents to a child should be in writing and signed by all parties. But most importantly, from my practice area, parents and children should also seek advice regarding the benefits of entering a binding financial agreement before or during their relationship, which will deal how that gift or loan is going to be treated in the event of a relationship breakdown.
Thank you, Phoebe. I think I might have forgot to I'm Dylan Chaplin-Burch, and I'm head of our family law department here at Making Partners. The other thing to consider, obviously, when looking at entering a binding financial agreement is that it doesn't need to be at the start of the relationship. It can be during the relationship where an agreement can be entered as well. It also, a binding financial agreement will help with respect to inheritances as well. If one party, if one child receives a large inheritance from their family, they can also enter into a binding financial agreement to assist in protecting that wealth as well. But obviously, if anybody has any questions or anything they would like to ask, we'll just save all questions until the end, and then we'll ask them all in the one go. So thank you very much, Phoebe, for that. Next, we've got Jack Conway, an associate in our Wills and Estates department, to speak to you about protecting your assets through estate planning. Thank you, Jack.
Thank you, Dylan. Thank you, everybody, for coming. As mentioned, I'm an associate in the Wills and Estates team here at Aitken. That means I have the privilege of speaking at events like this about dying and death and all those fun topics. The overall topic today is about protecting your family wealth. Now, normally we talk about protecting things. That's about keeping things, retaining things, but as the old adage says, you can't take it with you. If you pass away, assets that you own are going to be passed on to the next generation. But hopefully, through proper planning, you'll be able to achieve three things, which is ensuring that the transition and the process is a smooth one, that the assets are going where you want them to go, and that you're not actually losing wealth in the process. So at the risk of sounding a bit like a BuzzFeed article, I'm going to be talking about the 5 levels of wealth transfer preparedness today. Now, the bottom level, starting level, is what I call the it'll sort itself out level of planning. Basically, is if you have no will, no planning in place, what actually happens in that case to your estate? Well, one of the first issues that you have is that there's nobody in charge to start dealing with your assets or your estate after you pass away. So normally, if you had a will and you'd set that up, an executor would be appointed, and they would be the one who is in charge and starts dealing with things. If you don't have a will, then there's nobody formally appointed who can actually start taking some initial steps, dealing with assets or organising things, getting information. It can also be one of the first points in dealing with a deceased estate where some fights can arise. The person who normally has first dibs on becoming the administrator of an estate will be the spouse. But if there's children who have a reason to sort of want to dispute that, then that can be one of the first points right off the starting gate, where you can find some conflict and some animosity and potentially even legal proceedings over who gets to be the administrator in the first place. Now, talking about business assets or business concerns specifically, there's a number of disadvantages in not having an executive from that initial stage, particularly if there's an ongoing business that's running. There are obviously some immediate steps that might need to be taken or things taken at very short notice. On the tax perspective, getting information about tax or being able to meet the tax obligations that come with running a business can be quite a bit more difficult if you don't have a will that appoints an executor. The ATO is only prepared to talk to someone who's the legal personal representative, which means an executor of a will or somebody who's actually gone through the process of being appointed as an administrator of an estate. So after you pass away, the access that the family has and even the advisors have to tax information becomes very, very limited until the ATO is notified that there is a legal personal representative be officially noted on their system. So not having a will that appoints an executor puts you in an immediate disadvantage there and can sort of delay you complying with tax obligations, things like filing VAT statements, that sort of thing. Additionally, if there's a business being run through a company, a sole shareholder, sole director company, once you pass away, your role as director in that company will cease. There is a mechanism for appointing a new director quite quickly, but again, if there's no will and no executor appointed, then really you have to wait for the court process of getting letters of administration to be completed before you can actually make that appointment or transition. The other point is if there's no will or no planning that's taken place, probably things are in a bit of a mess and a bit of disorganization. So getting information or having your family figure out where the bank accounts are, who the advisors are, even debating or figuring out whether there's a will at all, and having to go through those investigations, that all adds time and stress. That can be avoided if you do the most basic of planning. Which takes us to level 2, which is actually having made a will. So it's a much better starting position. You'll have an executor who can do much of these things that I just explained. You'll also have a clear statement of who the beneficiaries of the will are, who gets what, and it won't be set according to what are called the intestacy laws that apply if you don't have a will. The process of actually getting the will through the courts, which is usually necessary to deal with a lot of the assets, through a process called probate. That's normally much smoother where there's a will than where there isn't, particularly if you have a partner who's not married, or as I said, there's some dispute in the family. There's extra sort of loopholes that you have to run through to get that process through. So having a will, much simpler in that space. Now we'll be talking a bit later on about sort of asset protection advantages that can be utilized in a will. But if we just talk about having a basic will set up, the normal way that beneficiaries become entitled is if they survive by 30 days, which is basically the standard term for a beneficiary to survive. Then from that time on, they're entitled to their interest under the will. Now that sounds like it's all hunky-dory, but if there are any family law concerns or bankruptcy concerns or risk that any of these beneficiaries are facing, then having that locked in entitlement after 30 days isn't always the best thing. If you're an undischarged bankrupt on day 31, then the assets that you're entitled to under the estate are probably going to pass to your trustee in bankruptcy, be dealt with for the benefit of creditors rather than the benefit of your beneficiaries. Sorry, lost my train of thought. And that's even if the estate takes longer to administer. So if the estate still takes 2 years, even if you survive by that 30 days, day 31, you're still in insolvency, but you might come out earlier than the time the estate is administered. Those assets are still probably going to be dealt with for the benefit of creditors rather than the family. So having a will is very important. A will doesn't deal with everything, which takes us to step 3, which is having your assets and your interests that fall outside the will and outside the estate adequately dealt with. So often people who are running a business might have trust structures or companies and assets of companies. Probably everybody who's working has an interest in superannuation. And if you're running a business, you might also have a self-managed superannuation fund as well. These assets tend to survive after you pass away. So a trust or a company doesn't die when you die. Your death doesn't mean that those assets are distributed automatically. Really, what happens is there's some sort of succession of control, and those entities continue on. On your death, if you're a director of a company or a trustee of a trust, those roles will probably cease on your death. Sometimes your executor will step into those roles or can be appointed into those roles. Other times, the actual structure of the documents will have different rules in place about what happens. So what's really needed if you have those structures is a really overarching look at precisely how everything's going to operate and what the best plan is for actually dealing with those assets, whether that's can be done through the will or whether there's some other documentation that needs to be entered into to make sure that that succession occurs appropriately. Life insurance is also another big asset that can fall outside the will. Normally life insurance, you can nominate beneficiaries directly rather than have the life insurance policy you pay through the estate and go directly to someone. If you're personally at risk and have some debts, then maybe paying a big life insurance policy into the estate is the best thing. So paying it out directly might be better. The other thing is life insurance is often used in business succession arrangements. So if you've got a business that's being run with a stranger or another party, then on your death, the surviving business owner might not want to really step into business with the wife of the person they were working with, or the husband, or even 3,000 children who don't have much interest in running a business with them. So life insurance is often used as a way to ensure that there's some equity there that's able to buy out surviving business owners. That can be a bit of a complicated structure that's a bit hard to go into here, but yeah, making sure that all of the assets and interests are taken into account is very important. Fourth level of protection is making sure that you are dealing with what happens if you lose capacity, not just if you pass away. So as we get older, as a society, more people are suffering from degenerative illnesses and dementia and lacking capacity to continue on. But loss of capacity can also occur suddenly. If you don't have planning in place about mental capacity, then probably what will need to happen is that you need to, or your family will need to apply to BCAT and go through the process with the tribunal to make sure that there's an administrator appointed. That can be quite messy and prolonged, and again, could be another breeding ground for these kind of family disputes and fights. So having powers of attorney that nominate somebody who can make decisions for you if you don't have capacity is very important, particularly when there's business obligations that might be carried on and at short notice, things like making sure staff continue to be paid and contracts are still dealt with and business runs appropriately. Having powers of attorney is a very good or necessary in most cases protection to have. Again, talking about self-managed super funds, having an enduring power of attorney is very important to make sure that that super fund will remain compliant with super law. If one of the members or directors loses capacity, you basically have 6 months within which to replace a director who has lost capacity and therefore probably ceased automatically to be a director of that super fund. Outside that 6 months, you begin to run the risk of that super fund being non-compliant. So having an enduring power of attorney step in and be appointed as director is very useful in that circumstance as well. And quickly, the fifth level of protection that can be offered is by having a will that establishes testamentary trusts. And again, this is making sure that your beneficiaries of your will are protected if they're facing their own personal, business, or family law risks. I talked before about the 30-day rule, and after day 31, your beneficiaries are entitled essentially to their interest in the estate under a normal will. there's a bit of a question about, do you actually want your beneficiaries to get everything? Because if they receive the assets directly, then they, are subject to all those risks from family law and business risk and all that sort of thing. So wills can, instead of directing the gift directly to a beneficiary, can direct that gift into a separate entity that's established by the will called a trust. So a standard issue testamentary trust will, if you're leaving your estate to your children, will probably set up one trust for each child. That child is in control of that trust and basically can deal with the assets more or less as if they were their own, but subject to the terms of the trust deed. So it's still providing for the family in the same way, but using a structure that can offer asset protection from a number of risks. Now, the standard issue having each beneficiary in control of their own trust does come with its own risks, particularly from a family law perspective. If the family law basically sees that the person is dealing with the trust and the assets as if they were their own, it's quite easy for them to kind of look past that structure and still make orders forcing the person to deal with those assets as part of a family law settlement. There have been cases reported where different structures have been adopted. For instance, there was one case where there was a son and a daughter who were both had testamentary trust established for them under their parents' will. The daughter was the trustee of the son's trust, and the son was the trustee of the daughter's trust, and they were very diligent about making sure that they exercised their duties as trustees properly and gave proper consideration to how they dealt with the trust and those assets. And when the son went through his own family law proceedings, the son's wife's lawyers tried to get that trust brought into the asset pool, and the court said no, it's not property of the marriage because the trustee isn't the party to the marriage. They're exercising their independent judgment. That asset should not be liable to be split up and divided amongst the family law settlement. That's not to say it's not a resource of that person, so certainly it's taken into account figuring out what assets are up for division, but they didn't actually deal with those assets specifically. So if you've got important assets, such as a business that you're in some way passing on to a child that you don't want to be pulled apart in a family law settlement, then a properly structured testamentary trust can be really good protection. So I don't know if I've run over time, but basic summary is don't leave it all to chance. Make sure you have a will. Deal with the assets outside of your estate, which is just as important. Ensure you're dealing with loss of capacity and powers of attorney, and consider having testamentary trusts in your will. Thank you.
Thank you very much, Jack. I know it's probably a bit much to think about death and divorce before 8:30 in the morning and the first coffee sneaked in. But really what we want to do here at Aiken Partners is really assist people in protecting themselves during what is one of, well, arguably the most stressful times that people go through, which can be death and divorce. Unfortunately, divorce now, about 50% of marriages end in divorce, and everybody does die eventually. So one of the things that we really want to be able to do is assist people in making sure if the unfortunate does happen, that a smooth and seamless transition can take place. But on a different note, Alex Nicol, one of our managing principals here at Aiken Partners, will be talking about insolvency and family assets, and also the role of the trustee and the power they have as well. So without further ado, thank you, Alex.
Death and divorce to insolvency, which is obviously everyone's favourite morning. So thanks very much for being here, guys. Some of the things I'd like everyone to take away from today, I suppose, are that planning for the worst case scenario, while it is a bit of doom and gloom, can be really important. And it's really key to think about things long term. All of these protections, particularly from an insolvency perspective and where I work, it's much better to plan for them and document them when things are all rosy and everything's looking great, rather than do things when things are imminent, whether that's business issues, whether it's personal debt, those sorts of things, because as we'll go through some of the powers of the trustee in a moment, the trustee really focuses on recent transactions. So if you document things appropriately and plan for the future, you'll be in a much better position when you do deal with these worst case scenarios. Phoebe and Jack have dealt with some of the strategies in both family law and estate planning. There are some other strategies that people use. Phoebe touched briefly on loan agreements in place where family members, whether it's mum and dad or others, do loan money to children or other members of the family. Discretionary family trusts are used in much the same way in an ordinary business context as Jack went through with testamentary trusts. And security arrangements can be in place, particularly where money has been loaned to family members to preserve the asset itself. All of those things, if they're documented appropriately at the time, can form a really strong protection against the trustee if the worst case does happen and a child or member of the family does go into insolvency. Obviously, taking appropriate advice at the time is really important, because in a family law context and in a general insolvency context, the trustee will be looking at the commercial terms of the agreement, and indeed things like whether repayments have been made, whether there's interest being charged, whether they're on arm's length terms, essentially. So plan in advance, take advice, and do these asset protection mechanisms while things are going well, not when things are turning south. I will just run through very briefly. I don't want to bore everyone with provisions of the Bankruptcy Act, but I will just deal very briefly with some of the things that a trustee can do, because that can inform some planning that you can do to protect against those things. So the trustee does have very broad powers when they are appointed to an individual who declares bankruptcy. They will investigate transactions that occur particularly in recent years, and they have power to claw back what are called antecedent transactions. So they'll investigate the conduct of the bankrupt, and the main sorts of claims that a trustee will bring are what's called a Section 120 claim, and that's where an asset, whether that's real property or otherwise, has been transferred for an undervalue to a related party within 2 years of the person declaring bankruptcy. So again, obviously there's a temporal aspect to that 2-year period, so it's really important to plan ahead. And it's really important that if you are considering transferring an asset, even if it's not in imminent contemplation of a bankruptcy, that you document it appropriately, that you analyse what a fair market value might be, and make sure that you are transferring that asset for that value. Section 121 is what's called a transfer to defeat creditors. So this takes away the related party aspect of it and just says that if there is any transaction, transfer of asset that is designed to defeat the creditors in a bankruptcy, then the trustee can claw that back and distribute it for the benefit of the creditors. Again, very important to document. It's a defence to that claim under Section 121 if the transfer was done in good faith and for fair market value. So again, very important to document the arm's length nature of any transaction if you are transferring an asset out of the individual's control. Section 121A is the last one I'll talk about in any detail. That's where if transactions occurred and consideration is actually given to a third party rather than to the bankrupt person who's entitled to that money. So that's actually happens recently in the future, but instead of accepting the money for a transfer of a property or a transfer of a piece of asset, whether it's plant equipment or otherwise, the money will be paid to a third party. Never pass through my hands, you can't make any claim against me. Section 121A of the Bankruptcy Act says that's not right. The bankruptcy trustee can in fact claw back that money for the benefit of the creditors. So those are the sorts of powers that a trustee has, and when you're doing asset protection planning, you do need to keep that in mind, because at the end of the day, outside of the family law or an estate planning context, you do need to think about what might the worst case be and how do we protect against that. So just to sort of summarise the points from our point of view, seek advice document anything you're doing, and try and plan when things are going well, not when things are about to turn south. So that's all from me today, Dylan. I'll hand back over to you, and obviously if anyone's got any questions, whether it's in the room or online, feel free to yell them out or type them into the question box. Dylan.
Alex, just one thing that comes out of Alex's talk as well is when sometimes you'll have a situation where husband and wife are still married, husband's business is going terribly or wife's business is going terribly, and they have a sham separation, but then they try and transfer a number of assets through a financial agreement from one to the other, saying they're separated, they're not at fair market value, as Alex said, and that's where they can be clawed back by the trustee, bankruptcy. So that's one of the things we see, a bit of crossover between our two practice areas where there is that overlap. But does anybody have any questions this morning from any of our speakers about anything? Mr. Burkett.
Hi, how are you, Dylan?
Oh, not too bad, mate.
Two things. First of all, a statement just to add to the overwhelming number of things for people to think about. If you've got a family member who's part of your business structure, either might be a business partner, a partnership, or a shareholder because you've given some of the shares or sold some of the shares to your son or daughter, or they've come into the business. The other thing you can think about is a partnership agreement or a shareholders agreement that deals with what happens if they are bankrupted or if they are separated or if a court places those shares or that business interest into somebody else's hands. The shareholders agreement can sometimes say, hey, if that happens, I get to buy your shares back at 50% of the value or whatever. And so that it's another mechanism that using a sort of a business structure, shareholders agreement, partnership agreement to have another way of having that protection. And that can also assist because I've certainly had clients who've ended up as a business partner who's an angry spouse, not the person they went into business with, and that can be fairly difficult. So that's just another thing to add to this, what is probably now an overwhelming number of choices. But the other thing is a family law question about binding financial agreements, but on the same track. If there is a family business where there are ownership structures amongst family members, is it worth commenting on the use of a binding financial agreement to secure that business interest for the family?
So are you talking, for instance, where a son or a daughter has an interest in a
Yep,
business?
my daughter has 50% of the shares in the company I own 50% of the shares in. Can the binding financial agreement deal with those shares in a manner that makes sure that those shares don't get sold off to a third party or end up in the hands of the spouse?
Yeah, absolutely. And that's one of the things, the point of the binding financial agreement is that when Phoebe says it's not one size fits all, it really is an individual document. A lot of people have a misconception about what a binding financial agreement actually is. It can be tailored to everybody's individual situation. For example, if you had that situation where you had shares, one party had shares in the business and they wanted to protect it, they could be excluded. They could be given nominated value at that time, or they could just be kept to the side completely. With respect to any family trusts or anything like that as well, they can also be included in the binding financial agreement to keep them separate in the result of separation between the parties. The whole point of the BFA is for there to be clarity at the time of separation as to what is actually going to happen. Without that, sometimes we see often in the family court where there are conversational agreements, where there is a slip of writing mum wrote down to say, oh, here, Johnny, here's $100,000, you need to pay me back by 2035. The court doesn't take fondly to that. They basically see that is an informal loan agreement and something that really doesn't carry the weight that it needs to. So that's why we say a binding financial agreement is important at the start of a relationship. And as Alex said, it's important to get these things in place while things are good. Once things go bad, it's often too late to be able to fix it. So as they always say, prevention is better than the cure. And that's what we were just basically trying to make sure everybody was aware of this morning, that there aren't many options available. Yes, Andrew Clark.
We got one from the internet that you probably just answered. Can you have a single asset BFA, or does it need to do with all the assets?
No, you can deal with individual assets. For example, if somebody, using a silly example, inherits $1 million just before the relationship, you can say, in the event of our separation, I get that $1 million back. Anything else we accrue during the relationship gets divided 50-50, 60-40, If there are multiple children, you can have other scenarios in there as well. But the whole idea is that there is a clear, defined exit from the financially from the relationship to try and avoid going to court, because going to court and ongoing litigation surrounding family law matters is not only extremely expensive, it's also very timely. Your 12 to 18 months of your life is hard to quantify in a dollar amount. The whole idea of a BFA is that you can get out of a relationship quickly, know where you stand and move on. The emotional toll that litigation takes on people is quite severe in some circumstances. So that's why we encourage people to actively think about it. Yes.
Where you've got a trust set up and it's maybe got a very open wording, same family trust, so you've got lots of people with a beneficial interest in that trust. Do they have any form of recourse if they feel that the trustee is giving preferential treatment to certain beneficiaries? Like, is there a risk there or not?
So are we talking about a family discretionary trust?
Yeah.
Yeah. This might be more of an Alex question than are you talking in a family law context, or are you talking just
any context really? Because the way ours was set up years ago, we didn't even have kids or anything yet. So the wording was very broad. It allowed for corporate beneficiaries as well. So I'm looking at it in terms of our structure, and it seems so interrelated. It doesn't actually seem to afford any protection at all, depending on how you look at it. Or is that not right?
I've got a sneaky nod from one of my partners who's going to answer your question. And
The answer is yes and no.
it depends.
So if it's a really clear discretion on the part of the trustee to give anything to anybody in the beneficiary class, it should be safe as long as they're properly exercising the discretion. So if what I do is I never even think about who I'm going to give it to, I always give it to you.
Yeah.
That's just how it is. Then I, as a trustee, and that decision to give it all to you may be challenged on the basis that I'm not doing my job, which is to consider all of the beneficiaries. I don't have to make a list of every 15th cousin, but if what I'm doing is not exercising that discretion the way the trust wants me to, thinking of everybody and making a definite decision, it can still be you, but I have to do that. But if what I've done is I've exercised my discretion and I've decided within that discretion I'm giving everything to you, it's generally okay. That this sounds like a lawyer looking for work. It does come down to the clause, and if you're concerned about it, it's worth just having that looked at. But generally, discretionary trust, your standard discretionary trust wording is pretty safe. It's just that the decision-making process needs to be proper, and the trustee who's got the role of looking after the assets and deciding how to distribute that income needs to have at least turn their mind to how they're going to do that, not let the accountant, for example, just tell you. Have a minute that you've thought about it, have a document every year that says, I'm a trustee, I've had to think about this is what I'm going to do. That's where you, with a usual good trustee, that'll be where your danger is just how you exercise the discretion, not the wording of the trustee, which is generally pretty safe.
And in insolvency context, the answer is very similar, because obviously there's the protections from defeating creditors. So if there's a typical distribution to beneficiaries that is then altered because of an insolvency position, then that may be able to be attacked by the trustee. So it's looking at the typical distribution. If there's an alteration to that, it can be attacked by a trustee.
And I think the same in family law. If I always give it to you, but you then separate from your husband and I say, I'm going to give it to her, sometimes the court will say, hey, the pattern of giving you everything for the last 10 years and then suddenly not. Sorry.
Yeah, it's just a claim to defeat a creditor, essentially.
So that's that. But sometimes there's not a lot to do about that pattern, because that's why you set up the trust.
We outgrew our trust years ago, so we just, on one of our trading entities, we just dumping it into a market company to pay company tax. And I'm looking at that every year, it's just 100%. And I'm sort of thinking, well, that's almost become now an asset of the, I look at that as not actually being protected at all.
So it's just worth, particularly if you did the deed a while ago.
Yeah.
Because even changes in the laws require the deeds to be updated. It's worth every now and again just stopping and saying, let's just have a look at all of this, both from a tax perspective but also from a legal perspective. Is it out of date? Is the pattern going to cause us any trouble? Do we need to think about that?
Yeah. Yes.
Is it possible in your will to force the beneficiaries to organise a binding financial agreement before they given the inheritance?
I'll leave this to Jack.
Yeah. That's an interesting question. I'm probably not quite sure the answer. You can kind of put conditions in the will, but it can be a bit dangerous, I think. I would probably expect, well, there's a few ways that conditions can be invalid. One of them is on public policy, and there's been, for instance, cases where people put conditions in the will to say that someone shouldn't get married or should only marry within the faith, or maybe not marrying outside the faith, or things like that. Sometimes they get struck down on the grounds of public policy that somebody shouldn't be able to dictate as a condition to say you have to take a certain action, particularly on something as important as marriage. Honestly, I don't have a direct answer for that one. I would think it would probably cause problems.
Sorry to interrupt you, because you're right that it's going to cause problems. The real answer is you do it before you die. So you set up the binding financial agreement that says when this money comes from the will, this is what's going to happen. Then the will will start. Then the will could probably have a condition that says, I've made this bequest on the basis that that is in place and that governs them. Then I think you'd have a stronger argument that if you said, if that has for any reason proved to be invalid, this gift won't take effect.
So you're saying,
Do it
like
now.
all the children need
Yep.
to have a financial agreement.
Well, I guess what I'm saying is if that's what you want, that's what you probably need to do if you wanted to be sure of it. If you leave in your will, in fact, it's unfair to do that to your kids, to be honest, to leave in your will that, hey, if I die, you've got to all go and have these fights with your spouses, and then you can have some money. Whereas if you tackle it now while you're alive and you can explain it to everybody, then you could have that in place. You'd need to look at the value of that against the.
And if you're trying to force something that requires two parties to agree, if one party doesn't agree, then the whole thing falls over. So
I think that's the important thing that I hope nobody missed was a binding financial agreement has to be agreed between the spouses or the partners. It can't just be one person says you have to sign this or it's over. There's obviously, there has to be consent, there can't be duress, there can't be fraud. There's a whole range of factors that are taken into account. So yeah, obviously you can say, don't sign this, the relationship's over, and that's fine, and you exit the relationship then. But if you put it in front of somebody and they say, no, I don't want to sign it, you can't hold their hand down and make them sign it. There's a whole range of case law where those sort of examples where people are migrating to Australia where English isn't their first language, when the BFA has been given 2 days before a wedding, for example, saying sign this or the wedding's off. There's a whole range of case law along those lines where binding financial agreements have been overturned. So make sure there's consent, make sure there's plenty of time for people to make decisions, and ultimately both parties need to be legally represented as well.
So you can't protect them if they don't want to protect them.
Exactly right. Yes, you can.
Not directly.
Yeah,
Where Jack was going to end up, because what he was doing was answering your question is, can you do it this way? Where he ends up after the hour of chatting to you is to say, have a testamentary trust.
Yeah.
So do what he talked about, a testamentary trust for our child that says, and have another trustee, separate trustees. We can say, and even express a wish, I don't want the spouse to get it if they leave them.
Yeah,
That's
and
where
you
you
can
put-
even go further than that, and obviously not include spouses as beneficiaries of the trust. So there are ways of setting it up. They're colloquially known as bloodline trusts, which basically says that you can leave it to your child, their children, grandchildren, and so on. But that's the limited class of beneficiaries, and that's going to be to some degree persuasive against the family law court that the spouse wasn't intended to have any right to that trust. And if they're not receiving distributions throughout the course of the marriage, then there's less chance that those assets are going to be falling into the spouse's hands in a split.
Perfect. Well, thank you very much for everybody attending today. I just want to let you know about our next breakfast briefing. The next breakfast briefing is on the 21st of April, and it's to do with the ATO in 2020. Obviously, coming out of the post-COVID world, there are a number of business concessions put in place, both personally and in a business context. But well and truly, the taxman is waking up after its COVID slumber and is now issuing directed penalty notices, seeking to wind up companies and cracking down on payment arrangements. So what we'll be dealing with in that seminar is obviously what to do, how to protect yourself, and just giving a general update of the recent ATO findings. So thank you very much to everybody for attending this morning, and have a great day.
Just correct them, we're not trying to back the time, it's ATO in 2022. And just a quick thank you to Phoebe and Jack, who did a fantastic job. Jack on very short notice, he got pulled in yesterday when one of our principals had to isolate because of our friend COVID. So well done, Jack and Phoebe.